Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Kirk B. Berkeley discusses the Chapter 11 process.
Today we're going to talk about the Chapter 11 process, and specifically that relates to Chapter 11 of the United States Bankruptcy Code. Chapter 11 historically was thought of as the reorganization chapter. That means a company goes into bankruptcy under Chapter 11, and that company would then reorganize its business affairs and restructure its debts and emerge from Chapter 11. Today that's not always the case. In fact, we're starting to see more and more Chapter 11 liquidations, as well as more and more individuals that are filing for bankruptcy protection under Chapter 11. But Chapter 11 still differs from the other bankruptcy chapters in a few important ways. Number one, the debtor remains in possession of its assets. So unlike a Chapter 7, where the assets are handed over to a Chapter 7 trustee, in Chapter 11, the debtor remains in possession. So if that debtor is reorganizing until a plan is confirmed, it remains a debtor in possession of its assets. Or even if the debtor is liquidating its assets, it remains in possession until that liquidation process is over and the case is either converted to a Chapter 7, dismissed, or some plan of liquidation is approved. And of course the same thing would go for an individual. That individual remains in possession of its assets until the conclusion of the case. And that's important because even though there are more Chapter 11 debtors that are choosing to liquidate their assets, Chapter 11 provides for the debtor to stay in control of that liquidation process rather than just handing over the assets to a Chapter 7 trustee. And sometimes that's because the debtor and its principals want to remain in control so that they can continue to draw a salary throughout the process, or they don't want some other party like a Chapter 7 trustee sticking their nose into the debtor's business. But there's often a lot of very valid business reasons for a debtor to stay in control, file a Chapter 11, and liquidate the business. Some of those business reasons might be to increase the value of the estate in the liquidation. A Chapter 7 trustee is not permitted without approval of the court, and approval of the court is not an easy thing to obtain, for the Chapter 7 trustee to actually run the business. So, for example, if a debtor wants to file bankruptcy, operate its business for some finite period of time, while it runs a liquidation process, the only place that the debtor can do that is in Chapter 11. So Chapter 11 serves a very valuable function in conducting an orderly liquidation of assets. Chapter 11 also provides for the appointment of a creditors committee. So that can be the trade-off. Instead of a trustee looking around at the debtor's financial affairs and seeing if there were transfers that should be avoided or making sure that the secured creditor is in fact secured, in a Chapter 11 scenario there will be a creditors committee appointed where creditors show sufficient interest. And those unsecured creditors, through the creditors committee, will then look at those same things that a Chapter 7 trustee would look at. And oftentimes it's more beneficial because they are the creditors that sold the goods to the debtor. They are the creditors that provided services. They might be the creditors that made loans on an unsecured basis to the debtor, and they have a better feel for how that liquidation process should run. They're more interested in the outcome. So it does allow for that watchdog role, while at the same time allowing a debtor to liquidate its assets and hopefully maximize value for creditors. At the end of the process, something still has to happen to end the case. The case could be converted after the assets are sold and then have a Chapter 7 trustee finish the case. It could potentially be dismissed upon the consent of the creditors and approval of the court. But a lot of times you'll see a liquidating plan approved where estate litigation such as preference actions, fraudulent transfers, and some minimal amount of money that might be left after secured creditors are paid are put into a liquidating trust, and then some trustee, plan administrator, or the creditors committee itself will pursue those actions to hopefully generate assets for creditors. But the Chapter 11 process will have worked its way through.
This has been another installment of the 5-Minute Legal Master series, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.